Hello and welcome to the Minimum Competence episode for Thursday, December 18th, 2025. I'm your host for today, Andrew Leahy, an assistant professor of law at Drexel Klein School of Law. On today's episode, courts blocking CFPB mass firings, doctors suing over vaccine rollbacks, DC Guard deployment upheld, and Trump's White House ballroom moving ahead. Let's remember to be still searching what we know not. By what we know, still closing up truth to truth as we find it. And read today's legal news. On this day in legal history, December 18th, 2019, the U.S. House of Representatives voted to impeach President Donald J. Trump, marking the third presidential impeachment in American history and his first of two so far. The impeachment followed a months-long investigation centered on Trump's dealings with Ukraine. House Democrats alleged that the president abused the powers of his office by pressuring a foreign government to investigate a political rival. His second article charged Trump with obstruction of Congress for directing executive branch officials not to comply with House subpoenas. The votes largely split along party lines, reflecting deep political polarization. Impeachment itself did not remove Trump from office, but instead formally accused him of constitutional wrongdoing. Under the Constitution, the House holds the sole power of impeachment, functioning similarly to a grand jury. Once impeached, the process shifted to the Senate, which is responsible for conducting a trial. Chief Justice John Roberts later presided over the Senate proceedings as required when a president is tried. The Senate ultimately acquitted Trump in February of 2020, falling short of the two-thirds vote needed for a conviction. Despite the acquittal, the impeachment reinforced Congress's oversight authority over the executive branch. The episode also highlighted ongoing debates about the limits of presidential power and the role of impeachment as a constitutional check. A federal appeals court in Washington reversed an earlier ruling that would have allowed the Trump administration to move forward with mass firings at the Consumer Financial Protection Bureau, or CFPB. Sitting as a full bench, the court blocked plans to cut as much as 90% of the agency's workforce and agreed to rehear the administration's appeal of a lower court order that had paused efforts to dismantle the bureau. As a result, the administration remains temporarily barred from gutting the agency while litigation continues. The legal fight has stretched on for months, during which the CFPB has been largely sidelined. By way of background, Congress originally created the CFPB after the 2008 financial crisis to protect consumers from unfair, deceptive, and abusive practices by banks, lenders, and other financial companies. Its mission includes enforcing federal consumer financial laws and preventing the kinds of predatory conduct that helped trigger the financial collapse in the first place. Supporters of the agency, including Senator Elizabeth Warren, praised the ruling as necessary to shield families from financial harm. Critics within the Trump administration have argued the CFPB is politically motivated, as protecting consumers from predatory financial practices is political, apparently, and should be eliminated, though they have also claimed in court that some version of the agency would remain. Complicating matters further, the CFPB faces a funding dispute over whether it can draw money from the Federal Reserve, raising concerns that it could run out of operating funds. A group of leading medical organizations asked a federal judge to allow their lawsuit challenging vaccine policy changes under Health Secretary Robert F. Kennedy Jr. to move forward. The groups argue that recent actions by Kennedy and the Department of Health and Human Services will reduce vaccination rates and endanger public health. They point to a directive removing COVID-19 vaccine recommendations for pregnant women and children without advance notice or explanation. The lawsuit also challenges Kennedy's decision to dismiss 17 experts from the CDC advisory panel and replace them with members more aligned with his views. That reconstituted panel later voted to scale back broad vaccine recommendations, including limiting COVID-19 shots to shared decision-making with doctors and eliminating universal recommendations for certain childhood vaccines. The plaintiffs claimed the panel was unlawfully reshaped in violation of federal law, requiring advisory committees to be balanced and free from improper influence. Government lawyers argued the medical groups lack standing because the CDC's guidance merely advises consultation with doctors and does not directly harm them. The plaintiffs counter that they have been injured by having to divert resources to help doctors navigate confusing and abrupt policy shifts. The judge indicated skepticism toward the government's standing argument, particularly in light of statements suggesting doctors could face liability for deviating from CDC guidance. A ruling on whether the case can proceed is expected before a scheduled January hearing. A federal appeals court allowed President Donald Trump's deployment of National Guard troops in Washington, D.C. to remain in place while legal challenges continue. A three-judge panel said the administration was likely to succeed in defending the deployment, temporarily blocking a lower court order that would have ended it. The ruling gives Trump an interim victory as he claims broad authority to use troops for domestic law enforcement. The deployment began earlier in the year and expanded after two Guard members were shot near the White House. The judges emphasized that Washington, D.C.'s unique status, because it is not a state, strengthens the presidential authority there. District officials who sued to stop the deployment said the decision is preliminary and does not resolve the underlying legal questions. The White House praised the ruling as confirmation of the president's lawful powers and credited the deployment with improving public safety. The case comes amid broader disputes over Trump's effort to deploy troops in several major cities, despite objections from local and state leaders. Lower courts have generally been skeptical of those efforts, rejecting claims that protests against federal immigration enforcement qualify as rebellions. The Supreme Court is widely expected to weigh in on the scope of presidential power in this area. A federal judge allowed President Donald Trump to continue work on a proposed White House ballroom, rejecting an emergency request from preservation advocates to immediately halt the project. The judge ruled that the National Trust failed to show imminent irreparable harm that would justify stopping construction at this early stage. However, he cautioned that the government may be required to reverse certain underground work if it ends up locking in a specific design. The project involves replacing the demolished East Wing with a large ballroom that would be significantly bigger than prior White House renovations. Trump has described the ballroom as a privately funded project and recently increased its estimated cost. Preservationists argue the administration moved forward without required public input and bypassed federal planning and design review processes. The government countered that the design is still in flux and that above-ground construction will not begin for several months. Relying on those representations, the judge found no immediate risk of irreversible aesthetic damage. He scheduled another hearing to reconsider whether the project should be paused as the lawsuit continues. For now, construction may proceed while the court reviews whether the administration complied with historic preservation and planning laws. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, peace hath her victories no less renowned than war.